Hey, everybody. Happy Wednesday. Welcome to True Crime Wednesday. We have lots to talk about. We have lots to talk about Karen Reed, but we also have a lot to talk about with Lori Vallow, too. Sorry about that. I'm a little scratchy tonight. So, welcome, everybody. I'm just going to take a little time and let everybody catch up. So, just wanted to say hello. I hope spring is peeping where you are. It is for us. It's supposed to be unseasonably warm tomorrow, which I'm looking forward to like crazy, and looking forward to a Central Oregon summer. As much as I complain about the winter time, there is no more perfect place to be in the summer than in Oregon. So, looking forward to getting up in the high lakes and doing some kayaking and all that stuff that makes living in the Northwest really worthwhile. So, welcome. Um, I wanted to start out talking about Lori Vallow. Now, her next case with Brandon Boudreaux is coming up um, on the 30th of May. Oh, Jackie Dotson, 90 degrees here today, she says. I don't know where you are, Jackie, but I'm just a little bit jelly. Um, a couple of things have come up with Lori Vallow recently. Um, Two things in particular that are kind of um, interesting, I guess, things that sort of give me a little pause. First of all, the court has filed in its court docket to notify Lori Vallow that the court was alerted to the fact that a juror in their interview, um, in an media interview after the trial was over, has said that that juror, someone announced after the verdict that they were aware that Lori had already been sentenced to 3 life sentences. Now, as far as I know, that juror did not share that with anybody else on the jury before deliberations took place. That is the appropriate thing for that juror to have done. Now, the court, when you are doing voir dire for juries, you are never looking at a, 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 a looking for a jury that has never heard anything about the case, because in this day and age you're just not going to get that kind of a jury. What you're looking for is a jury who hasn't already made up their mind about the case. Now, obviously, knowing that Lori has already been convicted of murder, presumably, um, it has to impact that particular juror's decision making. I just don't think how you can avoid it. But on the other hand, if that juror assures the court, the judge, that that information didn't impact their decisions on this case, then I'm not sure that Lori has a lot to complain about. So, as we say, Lori wasn't entitled to a perfect jury. She was entitled to a fair jury. So, would it have been perfect if they'd had a jury of no one who'd ever heard of Lori Vallow? Sure. But that's a tall order. And the other sort of double-edged sword is how how informed do you want your jurors to be? So if you are looking for jurors who don't know anything about your particular case. Does that mean that you are also looking for jurors who aren't well informed, are not the kind of people who seek out information and try to be well informed? Um, and are you are you setting yourself up with people who don't think critically? Let's face it, people who are more interested in the world around them and more curious are often better informed and so better critical thinkers. So that's something to think about too when you're looking for a jury and you're doing voir dire. So very quickly after the verdict was read, we'd heard some rumblings about the possibility that there were people on the jury who knew um, l- about Lori's earlier cases. And we talked about that before, about the fact that um, the judge would be asking, did you tell the rest of the panel prior to their deliberations and their decision? If the answer to that is no, then that knowledge didn't impact the full panel. Then the next question the judge would be asking is, knowing that you had that information, were you able to set aside that knowledge and weigh the evidence that was presented to you and make a decision and deliberate based on the evidence that was presented to you? Now, if that juror is honest and says, you know, I really had to say that I assume she's guilty because she was guilty in the other case, that's a problem. But if the juror says, I was still able to look critically at the evidence that was presented and to make my decision based solely on the evidence that was presented at trial. Um, then I think you probably are in a no harm, no foul kind of situation. So this also leads me into what has come up in the last day or so. And this this I have more trouble with. Um, Now I'm seeing in the chat, because I had not seen these interviews with this juror, who is saying that the juror said he was a not guilty um, until he read until he read the text messages between Lori and Alex. Somebody else is saying um, that the juror said he was a not guilty vote until he heard about the prior trial. So I don't really know. I haven't looked into it enough, but I will. But I've been totally immersed in Karen Reed. I'm here to tell you, I'm completely down the rabbit hole in Karen Reed. We're going to talk about that in a little while. So the next thing, the other thing that came up though with Lori Vallow is that the prosecution has filed a notice um, and essentially a 404, a 403B notice. And what they're saying is, if Lori Vallow opts to testify in the Brandon Boudreaux case, they will bring in all of her all of the information about her prior bad acts, including her convictions in Idaho and the circumstances of those convictions. Now, that's legal, but I think there's a real question about how that influences her right to testify or not testify. It makes me uneasy. She has she has an absolute right to not testify. She also has an absolute right to testify should she choose. Now, I think that it is reasonable for the prosecution, particularly um, i- in the instance where they're dealing with a a self-represented person. I think that it's really crucial for them to put all their cards on the table and to say, we're going to be totally transparent about the fact that our intention is to bring in this information if as impeachment information if she testifies. And that is the appropriate place for it to come in. So if Lori doesn't testify, as she chose not to in Charles's case, then there's no danger that the jury is going to learn about her past. So I think we, I will search out that juror's interview and we can talk about it next time. But it is concerning to me that she doesn't, um, that it puts her in a really, between a rock and a hard place. It puts her in a really difficult position because if she feels like she has a reasonable reason, a compelling reason to get on the stand and testify, precluding her from doing that seems unfair. So I guess it's something, I mean, it's one of those things that kind of makes you go, hmm. I think it's something to think about and to consider. Um, you know, every case is different, and every juncture of a case is a decision point, and every one of those decision points is going to be different for every case. So, where it might be a no-brainer in a different case, either to not have someone testify or to testify. In this case, because of the procedural posture, that's a law term, of the case, it, it means where the procedural posture is where you are in the process. So it's where you are at this point procedurally, not necessarily having anything to do with the substance of the case. It's purely where you are procedurally. So in this current procedural posture, she has a really serious decision to make. And there is a lot, she has a lot to lose in doing that. So um, before we hop over, because I do have something I want to play. Now I'm not going to play the whole thing, but right after her um, just within a day or two of the guilty verdict, she once again sat down with True Crime Arizona. This is interesting. Oh, excuse me. It truly is allergy season. Um, she sat down with True Crime Arizona. I think it's particularly interesting that these folks are competitors to Fox 10 and Justin Lum. I don't think she is a big Justin Lum fan. I know that she is not a big Nate Eaton fan. So I think it's interesting that she's kind of thumbing her nose a little bit at Justin Lum by giving um, uh, the CBS station uh, Arizona, let me see, what is it? 3 TV, I think it is. Um, Interviews, exclusive interviews. So she sat down with them, and I think it's just fascinating that she once again doubled down on her claims. So we're going to just watch a little bit of it. I have it at 125 speed just to kind of buzz through it. But one of the interesting things, hang on and let me share my screen with you. There we go. And, as we go along, of course, because this is fair use, I will be commenting. One of the interesting things is she comes in with this big file folder.
There you go. Make sure everything kind of squared up. Perfect. You got enough room? Yeah. Okay, perfect. Perfect. We're good? You guys good? Yeah. Cool. Well, it's been an interesting 2.5 weeks.
Has it only been that long?
Yeah,
Has it been like,
feels a little longer, I would say.
gosh, yeah, it went fast.
It went fast. Guilty. Did you expect that?
No.
Not at all.
I mean, obviously, I knew that's a possibility. Yeah, so it was a bit of a surprise, actually.
What made you?
A surprise? Really? It was a surprise that the verdict was guilty. I don't know why I'm getting all these ads because I have
Hey, Lori.
YouTube Premium.
How are you?
I mean, I shouldn't be surprised knowing.
So guilty, and yes, she was surprised. Yeah, she's still in her own little world.
What I know about the judicial system and how it works. So it still was just, you were there. So from what happened, I was surprised at that outcome.
And we didn't really see any noticeable reaction from you or really anybody else in the courtroom when that verdict was read. When you did hear it, what was your first thought?
So it's not a secret that I had a near-death experience, right? I talked about it at my sentencing. And when you have that experience and you go to the other side of the veil, you understand, you have a life review. You see your whole life, everything that happened to you, and you see what's important and what's unimportant. And you see what matters in life. So what matters in life is how you react to things, how you treat other people, and the love that you give while you're here on earth. And that's it.
So you felt not reacting was the best call in that moment?
No, I felt like I should have joy in every situation, which is what I was taught to do in heaven. So
you had a list of witnesses you could call, your parents, your sister, even your brother again, but you chose not to. And I think you resting without calling anybody was a surprise to everybody who had been following the trial. What went into that decision?
So did you read any of the motions that were filed precluding my sister and my mother from speaking about certain subjects?
Some of them, yes.
And then did you read any of the motions that were precluding me from asking certain questions to the law enforcement?
Yes.
So, and did you see all the people that they struck from my witness list?
Yes.
Okay. So
what did that leave you with?
That's what I'm saying. In the judicial system, the way that it works is they really don't let you put on a defense.
Really, Lori? Really? She's continuing to play the victim. They didn't let me put on a defense. I could have done so much better had I been allowed to put on a defense, which in Lori's parlance really means if I had been able to just have carte blanche to say anything I wanted to about anything and about anyone, and if I'd been allowed to say all the things, I would have been found not guilty. I don't believe for a minute that that is the case. I don't think Lori would have done herself any favors by saying more, of the jury hearing more from her. She definitely handed the jury her entire police interview and wanted them to watch it. And I've watched that interview over and over again that she did with Chandler Police. And it's creepy. And I can't imagine that anybody seeing it wouldn't think something is not right here. So I'm not sure that she was going to do herself any favors at all. So we'll just zoop ahead here.
So you didn't want Trina Kay to get back up there and present a lot more after if you were to have testified.
I didn't do it for that purpose. I just knew that that is a possibility.
We were talking to the jurors after the verdict, and they had a lot of interesting things to say. One of them,
I would be really interested to hear what they said. I didn't get to hear any of
Well,
that, so
I'll
I've
tell
been sleeping.
so one of them thought not guilty until closing arguments. Do you feel like you did not do enough in closing arguments to have convinced that juror to keep that decision?
I don't think that it was my job really to convince them. I was just trying to present it from my side, you know.
So this doesn't surprise me that there were jurors who were really not guilty until closing arguments. First of all, that's what we want. We want jurors who are committed to saying this person is innocent until you prove to me that she's not. And you prove to me beyond a reasonable doubt that she's not. That's the way our system works and the way we want it to continue to work. So it's not really a surprise to me that there was a juror who said that. I think one of the challenges with this case was because it's a circumstantial case, and we've talked about this at length about circumstantial evidence, that one of the most important things that has to be done is what you're explaining to the jury is a series of circumstances, a series of events that when you connect them together lead to them to infer that this person committed a crime because there's no direct evidence. Nobody saw her do it, and there's no recordings of phone calls with her and Alex. So there's no direct evidence, but circumstantial evidence is equal to direct evidence. And jurors are informed that circumstantial and direct evidence are the same. You don't give one more weight than the other. But what has to happen is in a circumstantial case, you have to stack up enough links in the chain that you can get from point A to point B and without reasonable doubt in between. The more disconnected links you have, the more likely it is that somebody is going to say, well, I don't know, you didn't connect the dots for me. So I felt all along that we really were not going to have a clear picture of all the connections. Now, Trina Kay at the beginning gave everybody a roadmap about where she was going to go. But I felt all along that until we got to closing, we really weren't going to have her connect the dots enough that people were going to say, I can go from A to B to C, and maybe D is missing, but I can see how to get to E and F and ultimately to guilty. So that was so it doesn't really surprise me that there was at least one juror who was on the fence until closing arguments.
A lot of them had the same questions that we thought. So just to kind of bring you into what affected them the most.
Sure. I'd love to hear that actually.
So all of them sat there wondering, where is TERRI? She's in the body camera footage.
Right.
Why is she not testifying? And they felt that there was a part of the story missing, which they didn't know about your previous convictions, but they were correct.
Did they not know?
They did not know. According to them, they did not know. And they shouldn't have known based
They
on
should
how
have known. And it was weird, right? Because it seemed like Trina Kay was talking around TERRI without talking directly about her, you know? So I'm sure that was confusing.
Would you have wanted the jurors to know that she's dead?
I was precluded from giving out that information. So that's the way the law works, right? We were both precluded. So that made it very awkward, don't you think?
But let's say you weren't. Would you have preferred the jurors to know that TERRI was dead?
I don't know that. I think they obviously did know.
Well, they said they learned afterwards. So as they were coming out, people were saying, you can now look up the case. So they were Googling things and they're seeing all these prior
So you
convictions.
didn't think that that happened during deliberations? Like maybe one person informed all of them that that was the case?
I mean, obviously,
I mean,
and I won't know.
That's what I'm saying. I don't know. I'm not saying I was there.
But they were upset when they found out that Tylee and JJ are both dead. For you, seeing Tylee on the video, I mean, what was that like for you? You were convicted in her death, but we're seeing video of her in that courtroom.
Yes, this is why I switched to injection-free weight loss.
So I am sorry, I am apparently not signed in to my premium account because I keep getting ads and I don't usually get them. Yep. So I'm not going to show more of that, but you get the flavor that she is unrepentant. She believes that had she been able to actually put on her case, that she would have been found not guilty. And I can't agree with her. And I think it's very interesting that she is still really holding tight. One of the things she says in this interview is that Tylee was the catalyst for Charles's murder. That still just every time I hear it, I wrote it down, and it still just grates when I think about it. She still insists that it was Tylee's fault. Tylee was the catalyst for Charles's murder. So now she has hung the blame for Charles's death on Tylee. Now she has hung the blame for JJ's death on Tylee. Now she has hung the blame for her own death on herself, on Tylee. How do how do they get there? That's it, it's still shocking to me that she's willing to go there. She did admit that being her own a lawyer was harder than it looks and different than she thought it would be. And she complained that she wasn't able to tell her story. Um, she didn't like the pretrial rulings that kept a lot of things out. And she insisted once again when the interviewer asked her about why she was so angry when at the woman who came in and testified who'd had dinner with Charles the night before, why she was so angry that Charles was dating when she was having an affair. She then categorically denied that she was having an affair, that until they got married, she and Chad were just best friends, which we know isn't true. She then went on and said the police made up a story based on how they interpreted the texts about Nephi, and that the texts were over everyone's heads because they aren't spiritual enough and haven't had near-death experiences. So she chalked up everyone's misunderstanding about the Nephi text, which really was a lot of the jurors said, was very telling. I'll be like Nephi, and so will you. And she says clearly that you can't interpret them because you haven't had a near-death experience and you're not spiritual enough. That it was really over everyone's head. Then she talked about the fact that her real goal is to help the other women who are in prison, and that this quote, "This will have zero effect on me in eternity." So she is still utterly convinced that she is above all of this and that none of this is going to have any impact on her in eternity. Wow. Just wow. Yeah. So, we will wait to see how her trial with Brandon Boudreaux goes, and we'll wait to see whether or not she testifies. I expect she will not testify because she doesn't want the next jury to hear about all of her convictions. And one of the things is, now we've talked about this before. When it comes to 403B, uh, prior bad acts or character kind of evidence, first of all, it has to be relevant and it has to be more probative than prejudicial. So in Tylee and JJ's case in Idaho, the prosecution was able to bring in Charles Vallow's death and the circumstances surrounding it, even though she had not yet been convicted, because they were able to make the case to the judge that it showed motive and planning and a whole lot of other things other than that she was just a bad person. So, but in this case, because chronologically, Tylee and JJ and Tammy's deaths happened after Charles's, those deaths couldn't be used to prove motive or planning or any of those things. So they couldn't be brought in. So those crimes didn't come in Charles's trial. However, Charles's death can come in Brandon's trial, and most certainly will come in for the purpose of proving motive, plan, all of those other things. Now, remember that Brandon Boudreaux was, Adam was involved, Lori's brother was involved with Charles in trying to help Lori, but Brandon Boudreaux was also involved. And Brandon Boudreaux's wife, Melanie, had initiated divorce proceedings based on Lori's visions in the temple about things that Brandon had been involved in, none of which were true. And if you'll recall, this is going back some in the history, so if you haven't been around for this case for a while, early on in this case, during the divorce between, the children were missing, nobody knew where they were, their bodies had not been found yet, and Melanie Boudreaux, now Pulowski, Melanie was in the middle of an ugly divorce with Brandon Boudreaux and was an ugly custody battle over their 3 children. And during the pendency of that, Melanie's lawyer and law firm, 2 lawyers in a firm, sent out a press release, sent out a news release to news organizations outlining all of the heinous things that Brandon Boudreaux had done. And they made the most outrageous claims. They claimed he was gay. They claimed he was a murderer. They claimed he had his parents had ties to the mob. They claimed he was a drug trafficker. I mean, they made the most horrendous claims publicly. And the first time they did that, Brandon Boudreaux's lawyer reached out and said, knock it off. None of these things are true. The second time they did it, Brandon Boudreaux sued them for defamation and slander, and won. So he sued both lawyers, and interestingly enough, both lawyers settled the case before it ever went to trial, because they had slandered him horrendously, and they settled it for $12 million. So Brandon Boudreaux collected $12 million because of Melanie's lawyer's malfeasance. And believe it or not, a year or so later, when Lori's trial was going on in Idaho in 2023, who comes to court with Melanie's but that same lawyer? Now, I think he's admitted in California and Arizona, I'm not sure, but he's not admitted in Idaho. But he came and stood by while Melanie came to court. Now, if you'll remember, Melanie came to court and admitted that she had watched Brandon Boudreaux's testimony prior in violation of the court's order, and the prosecution decided not to call her. So she got out of testifying by breaking the rules. So, but I was very happy to see that Brandon Boudreaux, who turned out to be a really stand-up guy, was able to hold them to account, and he ended up making $12 million out of it, and good for him. So, okay, so we're going to switch gears, and we're going to talk about this guy. This is, his name is, he goes by YNW Melly. He's a Florida rapper. His real name is Jamon Demons. This young man is accused of having I'm trying to figure out how to word this. He's accused of having staged a drive-by shooting, basically. He claims he was in a car with 3 other people, I think. And at that point, 2 of the people died right away, and the other person who's in the car also has been charged. And he claimed that they were the victims of a drive-by shooting. The police claim that the shots came from inside the car from him. Now, he had a trial, and they hung the jury. And since then, there has been the worst. There has been so much controversy around this case. First of all, the prosecutors claim that he and his lawyer were involved in witness intimidation, and that his lawyer has been under investigation for this supposed witness tampering for well over a year. A lot of this started when the prosecution committed some serious misconduct, including one of the prosecutors insisting that law enforcement lie to cover up the fact that she had seized his mother's cell phone without a warrant. So in retaliation, they've now gone after one of Melly's lawyers. And so this has been going on for a year. So the prosecution won't tell the defense what it is she's being accused of. So they have a probable cause. They had a warrant and a probable cause affidavit, but they won't. The judge, under Florida law, they don't have to release the probable cause affidavit. So Melly still has no idea what it is that his lawyer is being accused of. But here is the really troubling thing about this case. He has been in custody since February 13th of 2019. As of today, he has been in custody 6 years, 2 months, and 17 days, and he is unconvicted. His first trial ended in a hung jury. So the defense is once again asking for bail because the trial isn't set until September 10th of this year. So this young man has been in custody over 6 years, and he is still pre-trial. That is well beyond any sort of limitations on speedy trials. I'm sure a judge is going to say, we couldn't predict that there was going to be a hung jury. We couldn't predict that there was going to be a corrupt prosecutor. We couldn't predict all of these other things. But nonetheless, it's really unconscionable. And one of the problems is the longer a case goes, the more likely it is it falls apart. Memories fade, witnesses die. It's a long drawn out process. We saw this in the Young Thug trial. We saw a lot of witnesses that were suddenly, I can't remember, and so it really is pretty unconscionable. And they've asked again that he be granted bail, and I actually would be surprised if he doesn't get out on bail. With, I'm sure, really strict, stringent requirements and GPS monitoring and all that stuff, but nonetheless, 6 years is a damn long time to be held without having had a trial. So that one, I think he may be able to talk his way out. So we'll see. There are some more hearings coming up, and I'll be following those, and we'll have a chance to talk about those, including the bail hearings. So, but you're right, Julie, it is wrong that he has been held. He was denied bond from the very beginning, and he's been denied bond at every request. And I'm not going to say it's not unusual in a murder case for someone to be denied bond. That's kind of par for the course for there to be no bail, or for the court to set bail in an amount that's not possible, that's so high that the person can't post. But there's just so many shenanigans that have gone on in this case that it's hard to believe that this guy, 6 years in, and still hasn't had a trial. The first trial was hung. The prosecution came back and were adamant that they were absolutely going to stay on it and retry him. So sorry, I was catching something in in the comments. Somebody was asking about P. Diddy, and that is a case I just have not been following very much. Thank you, Edie Ruth. I've heard that it's supposed to start next week. I also saw something that the defense had asked for more time and the judge had denied it. So I really don't know where they're at. It wouldn't surprise me if the trial starts next week, because I think this judge has been in a real serious rush to get this trial done. So it wouldn't surprise me either way. I don't know why. I guess it's because there's so many other people who are so interested in Diddy's trial that I don't know, not that excited about it. So, we're going to shift gears once again, and we're going to talk about this lovely lady. This is Tiffany Adams. She is one of 5 co-defendants. She is the grandmother, and she is one of 5 co-defendants being held in the murder of Veronica Butler and Jillian. Why don't I have her name written down here? She was the pastor's wife. I know somebody in the chat will put it up for me. So this is the case where Veronica Butler won custody of her 2 children in 2021. Kelly, thank you, Jillian Kelly. Thank you, Rachel. Rachel's been on this case and she's keeping me up to date on it. So just bring everybody up to speed. So Veronica Butler and this woman's son had children together. And they they split, and Veronica Butler won custody of the children in 2021. But a year later, lost custody to the son after this woman, Tiffany Adams, accused one of Butler's relatives of essaying the kids. And then the father was granted custody, and this woman, his mother, the grandmother, at some point just took custody from her son and then filed a motion and intervened in the son and daughter-in-law's custody battle. The suit alleged that Adams, some of this was that was alleged in the custody suit because Veronica Butler was poised to get custody of her children back from Tiffany. And part of the allegations in that suit were that Tiffany Adams, this woman, threatened the judge in the custody case and falsified documents that led to her son getting custody. So Butler was right on the verge of getting custody of the children back. She had been required to have supervised custody only and to provide a supervisor. And so Jillian Kelly was her pastor's wife, went with her to pick up the children. Now they lived in geographically fairly separated, and they would meet in that in a middle ground, which was this place where 4 highways came together in Oklahoma. I mean, it is just I don't know, maybe they're in Oklahoma and it's entire, I don't know, it's between 2 states. But if you've seen where they met, it's just this place in the middle of nowhere where 4 roads come together. There isn't even a business there. There's an old building that's boarded up. And Veronica Butler and Jillian Kelly just disappeared. And they claimed that she never showed up for the for the handoff. And Oklahoma and Kansas, you're right. It's Texas County, which always throws me off, but it's Oklahoma and Kansas. Thanks, Tiff. And so they claim that she never showed up. Well, 3 or 4 days later, when they can't find either one of them, police start looking into it. They find her car. They find blood in the car, and they eventually find her body. You're right, Tiff. This is the bad Tiffany. We have bad Tiffany's and bad Loris. So they find their bodies, and now this woman and her, I'm not sure whether she's married or not, or her significant other. The two of them, another couple, and one other man. So there are 5 of them. She is the instigator who gets everybody together and who sets everything up. She goes out, buys tasers, buys walkie-talkie radios or burner phones, and so she's the one who sort of masterminds the whole thing. And so they at least two of the co-defendants have now pled out and rolled over on the others. She has still been firm that she's not going to plead guilty, but we'll see. So we're still waiting to find out what's going to happen to her husband, boyfriend, and one of the other of the couple. But 2 of the co-defendants have already rolled over and testified at her husband's preliminary hearing. After that preliminary hearing, she waived preliminary hearing, kind of like Chad and Lori. So the initial preliminary hearing was held. The witnesses testified against them. And so they are scary people. They are part of a group called God's Misfits. And no one really knows quite what this group was all about, whether it was a cult, whether it was some sort of a religious group, whether it was a club. Nobody quite knows yet what God's Misfits are. But the one thing they do know is that despite these people being kind of country trash, I'm trying to be diplomatic and I'm failing miserably. They were fairly well to do. They all owned quite a bit of property, and so it's going to be interesting to see, because it seems like they're from a fairly small town, and it appears that they had a fair amount of influence in the town. Now, whether that's good influence or bad, they had a certain amount of influence in town. So, I mean, she did think that she could threaten the judge and get her way. So that one's going to be really fascinating to see. The next court date is May 14th. Now, one of the things that came up recently was Tad Cullum. So the couple, this is the husband of the couple, filed a motion to recuse the judge that's been hearing the case because the judge represented Tiffany Adams in a divorce in 2011. Now, she divorced somebody who's not even remotely involved in this case, and it was in 2011. The judge denied the motion, saying that there was no possible way that it was a conflict, which he's right. in order for there to be a conflict, there has to be some sort of overlapping cases. So the fact that he represented her in 2011 in a divorce really doesn't matter. Now, if he had represented her in a divorce from one of her co-defendants, that clearly would have been a conflict, because there was a possibility that the judge could know information about one of the co-defendants that could disadvantage the other co-defendant. But in this case, it's not a conflict. So the judge denied it. The next court date for them is on May 14th. And that, I think, is going to be when they're going to try, at least, and set a trial date. Because as far as I know, these folks have not waived speedy trial. So we will see. Next, let's talk about these guys, the Menendez brothers. So this case goes back to the 80s when these two brothers were accused of having murdered their parents. And one of the brothers claimed from the very beginning that they were the victims of abuse at the hands of their father. Their father was a music producer, as I recall, and for a long time was big in representing and in managing boy bands, including an 80s boy band called Menudo. And years later, two bits of information surfaced. One that now the Menendez brothers were tried, and their first trial ended in a hung jury. Interestingly enough, they presented all of the evidence to two separate juries. So each brother had a jury. And that trial ended up in a hung jury. They retried the brothers, one jury, and they were convicted. So they have been life without parole. They've been serving life without parole sentences since the 80s. Many of their family members support them being resentenced. So two things surfaced that didn't come up at trial that could have potentially been mitigating. If the brothers were to be believed that their father had abused them, then potentially that could have been a mitigating factor. Add to that the fact that the sentencing rules have changed significantly since the 80s. It was during the 80s that the pendulum really swung towards more mandatory sentences, more life in prison sentences, more less ability for judges to have discretion, less mitigation. And so that was a period in history when sentences were a lot more severe in a lot of states. And there were a lot of states that went to determinate sentences and sentencing schemes that included mandatory sentences. So, and it was a different time when I think there wasn't as much consideration given to childhood abuse. And so many members of their family have asked repeatedly and petitioned repeatedly for the district attorney to consider resentencing. So last year, the elected district attorney filed a motion asking the court to consider resentencing the Menendez brothers. And he was then summarily voted out of office, and a new DA took over. When the new DA took office, he then asked the court to withdraw that motion for resentencing for the Menendez brothers. And so up until recently, we've been waiting to find out whether or not the judge was actually going to consider the motion or allow the new DA, to withdraw it. The judge recently decided that the new DA could not withdraw the motion. Now, he can argue against the motion, but he certainly can't, according to the judge, he's not allowed to just summarily withdraw it. So the judge set a hearing on the issue of whether or not they were going to be resentenced. So one of the reasons why they want a resentencing is because of a couple things that have surfaced since their conviction and that were not considered during their initial sentencing. One was a letter that one of the brothers wrote to a cousin long before the murders, while they were teenagers, about the essay that their father was subjecting them to, and talking about wanting to harm himself because he couldn't take it anymore and those sorts of things. The other was information that surfaced that one of the members of the boy band, Menudo, had experienced a similar experience with the Menendez father that had been covered up. And so the family was very encouraged that the old DA had asked to rehear things, and that they had this additional evidence. And we were all set. Like Judge Bev and Karen Reed, you're all set. We were all set for resentencing. The judge said no, the DA couldn't withdraw the resentencing motion, and that it was to go forward. However, there were some motions filed. One was to recuse the entire DA's office. I think that's LA County. And the other was a motion to on whether or not a new comprehensive risk assessment report was going to be admissible. So those two issues had to be decided before they could have that hearing, and the decisions haven't been made on those yet. So we're still waiting to find out whether the Menendez brothers are going to get resentenced. So, and now let's talk about Karen Reed, because the Reed case has been unbelievable. Now, we're only on the prosecution's case in chief. So we have weeks and weeks to go on this case. But there were some pretty compelling testimony and cross-examination that happened this week. Probably one of the most impressive and most convincing, maybe, was Ian Whiffen. Now, y'all know that cell phone data is becoming the crux of so many cases. Digital data is becoming huge, and it's only becoming bigger and bigger. So Ian Whiffen was their expert who came to court to explain where everyone's telephones were. He also came to court to explain this strange Google search. Now, and we have to start with, he started out talking about John O'Keefe's phone and where John O'Keefe's phone was, when it turned on and off, when the camera turned on and off, when where it was, and to what degree of certainty it could be plotted, and what the health data said in terms of how many steps he took and all of those things. So the next thing he testified to was Jen McCabe's telephone. Now, he testified, we had, hang on a minute, I'll think of his name. We had the police officer, the trooper who came in and talked about all the text messages between Karen and John and read them all, and they all got read into the record, and so he Garino is his name, Trooper Garino. He will be back and forth because there's plenty more text messages and communication, but the Ian Whiffen was actually really in charge of crunching the data and analyzing the data and figuring out where everyone was. One of the questions in the Reed case is, did John O'Keefe go into Brian Albert and Nicole Albert's home? Nicole Albert and Jennifer McCabe are sisters. Brian Albert is a Boston cop. Did John O'Keefe go into that house? And how did his body end up in the yard? And one of the prosecution believes that Karen Reed hit John O'Keefe with her car. The defense believes that John O'Keefe went in the house and there was some sort of an altercation, and John O'Keefe was beat up and thrown out on the yard, in the yard. So when Jennifer McCabe's telephone was extracted, one of the things they discovered was a search on Google, supposedly at 2:27 a.m. Now, if you're following the case, Karen Reed pulls up in front of the house with John O'Keefe. He then, according to her, gets out of the car and he doesn't come back. She finally gets tired of waiting for him and leaves. And that is somewhere around 12:30. She logs back into the Wi-Fi at John O'Keefe's home, where she's gone after she drops him off, at 12:36. So somewhere around 12:30-ish is supposedly when he gets dropped off. So Jennifer McCabe's phone Googles how long, well, she misspells it, but essentially it's how long to die in the cold at 2:27 a.m. Now, she claims that she didn't search that at 2:27 a.m., that she searched it at 6 a.m., 6:30 a.m., when they went back to Brian Albert's home and found John O'Keefe in the snow. So that's the controversy. Did she search it And did she then research it at 6:30 in order to make it look like that's when she was searching it, to cover up? Or is there some sort of glitch in the search engines? So Ian Whiffen claims that, and it's all very technical internet stuff, but essentially what he says is when Jen McCabe at 2:27 a.m. did a Google search of something else, something having to do with sports scores from a game her daughter was in, that Google tab stayed open, and that when she searched for how long to die in the cold at 6:30, it registered on that 227 Google search page. That's their contention, that she really did the search at 6:30, but because that tab had been open, that Google search tab had been open at 2:27 a.m., that's how it got marked that way. So there's so much more going on, as you might imagine. Ian Whiffen works for Cellbrite. Now, Cellbrite is one of the leading companies that make software that extracts data out of telephones. There are others, but it's one of the leading ones. Well, this guy works for them. And as a result of this trial, he reported this glitch to Cellbrite, and Cellbrite has now completely changed their search functions to account for that. So the question is he right? And if he is, how many people have been convicted and are in jail right now because of this glitch? Or is he wrong? And did Jen McCabe really ask for how long to die in the snow at 2:27 a.m.? This is long after Karen Reed has gone, long after all the people have left the party at 34 Fairview, which is the house Brian Albert and Nicole Albert's home. Now, there are some really fishy things about this. Brian Albert is a 30-year Boston cop. He's a first responder. He's on the fugitive task force. He's a very practiced cop. The Canton police assistant, I think, police chief, lives across the street. And yet, at 6 a.m., when all of these fire trucks and ambulances and police cars show up, Karen Reed is reportedly wandering around in the yard hysterically screaming. There's all of this activity. There's probably, I don't know, 15, 20 people on the Albert's front lawn. Brian Albert does not wake up. Nicole Albert does not wake up until Jennifer McCabe testifies that she goes in the house. The house is unlocked, which is weird for a cop, especially somebody who's on the fugitive task force. It's a little weird. She goes in the house, goes upstairs, and wakes them up. They're still asleep in bed, and wakes them up to tell them that they have found John O'Keefe, their friend, on the front lawn, and he's probably dead. Another strange thing is the Alberts had a German Shepherd dog. Now, this dog had been a member of the family for about 6 years. She was known to not like strangers, to not like people in her house, and she was known to have bitten neighbors and to not get along with other dogs. And there's a suggestion, although it's never been confirmed, that she was a failed police dog, that she was a police dog that washed out of training. She's a big dog. She's like 70, 80 pounds. Okay. And everybody in the neighborhood says this dog is not a good dog to be around, and she barks all the time. But when Jen McCabe goes in the house, and everyone knows that Chloe, the dog, sleeps in the Albert's bedroom. But when Jennifer McCabe goes in, nobody in any of the house, in the responders, in anybody who's there on the scene, hears her barking. Jen McCabe goes in the house. She testifies, no, Chloe wasn't there. She didn't bark. I didn't see her. She wasn't there. I didn't see her. Really weird. Okay. Now, the defense claims John O'Keefe has injuries along one arm. They claim that those injuries, which are a bunch of parallel scratch lines and abrasions and some puncture wounds, are from a dog. And that somehow the dog was out of the house by the time the police showed up and by the time John O'Keefe was found. So that is really interesting. But so Karen Reed has a team of lawyers, and some of them kind of specialize a little bit more than others. Bob Alessi is one of the lawyers, and his background is technical, and his forte is cross-examining experts. Rumor has it that he charges $1,300 an hour. And I'm here to tell you that if he does, he's worth it, because he did an incredible job of not only calling Ian Whiffin's findings into question, but doing it in a way that was completely understandable to the jury. One of the problems with experts is you lose the jury. The jury's eyes just glaze over because it's so much technical stuff. But Bob Alessi was masterful in not only really calling into question Ian Whiffin's findings and his credibility, but also doing it in terms where he never lost the jury. The third thing he did was he set up their expert witnesses that are going to come in their case in chief. So he had 3 jobs, and he did all of them really masterfully. So if you get a chance and want to go back and watch Bob Alessi's cross-examination of Ian Whiffin, it is really a masterclass. The other witness that was particularly interesting was Jennifer McCabe. Now, we heard earlier from Carrie Roberts. Carrie Roberts was a friend of John O'Keefe's, more a friend of John O'Keefe's than Jen McCabe at that point. And Carrie Roberts knew the family, and when John O'Keefe took over as guardian for his niece and nephew, she kind of stepped in and was very helpful. They had kids the same age, and as did Jen McCabe. And so Carrie Roberts really was more connected than Jen McCabe was at the time. But Jen McCabe, the party that had happened that John O'Keefe was supposed to go to, happened at her sister's house. Her sister and brother-in-law, her sister Nicole and her brother-in-law, Brian Albert, the Boston cop. So Alan Jackson did the cross-examination of Jennifer McCabe. Now, you may remember from the last trial that Jennifer McCabe was a very combative, really difficult witness. She'd had a bit of a glow up this time. She was a little softer. She was a little bit less confrontational on direct, but she certainly got her hackles up when Alan Jackson started cross-examining her. One of the first things he did, which I thought was really smart, was he went through and talked about the Alberts connections in the community. The Albert family and the fact that this person, Jennifer McCabe, is kind of at the middle of it because her sister's married to Brian Albert, and there's all of these family dynamics that connect them up to local law enforcement. They're friends with the Proctors, they're friends with the Lanks, they're friends with a lot of other people, a lot of other law enforcement agents. So he did a really good job of pointing out Jen McCabe grew up in Canton. She went to high school with a lot of these people, and that she has long time deep roots in the community and lots of connections. So Alan Jackson has been doing his best to be pretty surgical about this cross-examination. But I have to say that I don't think that he is being as effective this time as he was at the last trial. But we're nowhere near done. So tomorrow is a day off for the Reed trial. And then he will continue his cross-examination of her on Friday. So it's kind of, that break is kind of a double-edged sword. And one way it gives the witness time to think through some of the things they've said and maybe do some cleanup. But it also gives Alan Jackson a chance to go back and study some of the things that she said on direct and go back through and clean up some of that stuff. So I expect that we're going to see some fireworks on Friday. One of the things that came up was that she was interviewed by the FBI. Now, they didn't say the FBI, and they tried to dance around it a couple of different times. Alan Jackson called them the agents and had to kind of step back because they were trying to dance around the fact that these folks were from the FBI. Not because the FBI was involved, because that happens often. We see cases where FBI agents come in and testify, where the local local law enforcement have asked for the assistance of the FBI. Okay. That's not this case. The FBI got involved because there were concerns brought up about the validity of the investigation, about corruption, about, and of course, they had a dead police officer. So the FBI has gotten involved. And so they did not want to go into the fact that the FBI is involved because the investigation is suspect. So she admitted, yes, that she did give an interview to the FBI. So the FBI approached her. Originally, she was just getting out of her car after having taken kids to school, and they caught her as she was getting out of her car, and she didn't admit that she was Jen McCabe. She said she wasn't the homeowner because she thought they were selling something, is what she said. So when she got in the house, they called her and they explained to her who they were. And she said, yes, I'll talk to you, but give me 10 minutes. Now, she claims that she just rolled out of bed, taken her kids to school, hadn't brushed her teeth. She needed a moment to get herself together. But in that time, she made some phone calls. So when the FBI 10 minutes later sat down with her at her house, they asked her if she had made any phone calls in that time. And she said she had called her husband, Matt, and she'd called Carrie Roberts. Now, Alan Jackson tried to get her to admit that she was talking to Carrie Roberts to find out, has the FBI been there already and what did you tell them? But she wouldn't go there. So, but it still certainly raised doubt with the jury, even though they're not told it's the FBI. I think they can surmise it. So, one of the things that Alan Jackson said was, isn't it true that when you sat down with these officers of this other agency, they informed you that lying to them, even during an interview, you could be prosecuted for lying to them? And that is true. When the FBI shows up, if you lie to them, you can be prosecuted, even in just a basic interview, not under oath. So they asked her who she'd called. She told them she had called Carrie Roberts and that she had called her husband Matt because she wanted him to come home. So while they were in the middle of the interview, Matt did come home. They asked her repeatedly if she'd called anybody else, and she said no, she had not. After, and this comes out a little bit at a time because it's hearsay and it gets objected to, but apparently afterwards she told Matt that she had not been truthful with them about who she had called, and Matt had a fit and said, you better call him back and fess up because you could get prosecuted, and we don't need that kind of grief. So she did then call back and claim that she had forgotten about the other 3 phone calls that she made during the 10-minute time before they showed up at her door. And interestingly enough, the people that she called the witness advocate at the DA's office, and then she called Brian Albert, the homeowner of the home where John O'Keefe was found, who is her brother-in-law. Now, there wasn't any discussion because it would be hearsay about what they talked about, but she called him. Why would she call him? She was giving him a heads up. The FBI is sniffing around. Very suspicious. So, then something happened in court, which I don't think anyone is really clear on. The judge suddenly sort of, not at a place that you would expect to be a stopping place, said, I need to see the attorneys at sidebar. The next thing we know, the judge has cleared the courtroom. The jury is taken out. The judge clears the courtroom. I mean, everybody who's in the courtroom is sent out into the hall. And they're not even allowed to stay in the hall near the courtroom doors. The only people who are left in the courtroom are John O'Keefe's family, Karen Reed's family, the lawyers, and Karen Reed. And there is a lengthy lull in the trial. We heard a text, we heard somebody on Twitter posted that Paul O'Keefe, John O'Keefe's brother, who is not the nicest guy, I don't think, was in the DA's office, but we don't know why. And then court reconvened as if nothing had happened. We still don't know what that was all about, but it's very strange because that is not typical. Now, there was one other thing that was going on at the time. The DA in Aidan Carney's case, he's the YouTuber, goes by the name of Turtle Boy, who's been a very vocal advocate for Karen Reed and very vocal about the corruption in Canton. and has been charged with witness tampering and witness intimidation. The DA had filed a motion again to revoke his bail, and this time based on something he said on one of his YouTube episodes that supposedly was threatening to one of the law enforcement agents, Officer Tully. So I don't really know whether what happened in Karen Reed's trial had anything to do with that, but there was a hearing today in Turtle Boy's case. And the judge took it all under advisement and didn't make any decisions. There's some stuff going on about discovery and about whether or not they can get into cell phones, because there has to be in most states they call it a taint team. What that means is that device has to be given to a neutral third party who has to look at that and decide whether or not there's any attorney-client privileged information on it. One of the things that this guy Turtle Boy has claimed is that he's a journalist and that he has communication with sources on his phone, and that should be exempt as well as attorney-client communications. So the judge is sort of chewing on all of that, trying to figure all of that out. It's really kind of a gnarly First Amendment issue. This guy is known to be kind of a shock jock, to be kind of profane, not kind of, really profane, and kind of nasty. But the people's right to First Amendment, they have a right to speech, even if it's offensive speech, as long as it's not fighting words or yelling fire in a crowded theater or, a few other pretty narrow exceptions. So the DA has been consistently trying to go after this guy for what his lawyers say is protected speech. So I don't love the drama around all the people who are pro and against Karen Reed, and I don't go there. But I do think that that in this age of YouTube creators, there is new ground to be made, new law to be made around First Amendment rights. And in this time where media is so immediate. I mean, gone are the days. I grew up back when the Vietnam War was going on, and if you had video, you had tape at that point, a film that you wanted on the 5 o'clock news, you put it on a jet and you flew it by the most expedient route from Vietnam to the US and got it on the air. But that wasn't that meant that news was a day old by the time you got it. We weren't in this satellite news immediate 24-hour news cycle. And so as we've become this 24-hour a day small creators like us, being out there, it's a different world. And so I really do think that that the courts are having to look at balance the First Amendment against a person's right to a fair trial. So, courts' whole jobs really are to look at balancing different parts of the Constitution and deciding what takes priority. Certainly in the appellate court and Supreme Court level, that's their job. And I think we're just going to see more and more of that. So this judge is trying to determine whether or not the things that he said on his channel, which they played some of them in court. I'm not going to go into them. They're pretty offensive. They're pretty explicit, but is he entitled to make those offensive comments, and are they protected speech? Or do they rise to the level of actually being fighting words, being threats? So that's going on. So back to the cross-examination of Jennifer McKay, because that's where this case left off, with Alan Jackson not finished with his cross-examination of Jennifer McKay. One of the really pivotal things in this case is there are many witnesses who say that they heard Karen Reed, who had a lot to drink and was in an absolute, undisputed, that she was in an absolute state of hysteria. She was in a complete panic and hysterical. So she had been texting John and trying to reach John since she left 34 Fairview at 12:30 whatever that night. And he had been not contacting her. Now, John was never one to leave his niece and nephew alone. And Karen had not planned to stay the night at John's home. She was going to go to her own home. They didn't live together. So she was not going to stay the night at John's. And one of the things that really panicked Karen was the fact that John didn't come home and he left his niece and nephew home alone. And that was something he would never do. And so it's undisputed that she was in a completely irrational, hysterical frame of mind. And it's also undisputed that she said on several occasions to several people within the hearing of quite a few different people, "Oh my God, could I have hit him? Did I hit him? Could I have hit him?" There are only two people in this entire case who categorically say that she said, "I hit him." Not could I or did I, but I did. Affirmatively said, "I hit him." One is Jennifer McCabe, and the other is a female EMT. So difficult to really understand or try and parse that. So Alan Jackson spent a long time talking to her about all the holes in her testimony and all of the sort of blank spots in her testimony. So he spent a great deal of time going through all that, pointing out to her that when she testified in front of the grand jury in this case, that she never told the grand jury that Karen said, "I hit him." And in fact, told the grand jury that Karen, in front of that female EMT, asked, "Did I hit him? And could I have hit him?" So she claims over and over again that she heard Karen Reed say, "I hit him." And she's been adamant about it, and she's not backing down. I think she came across better this time than she did the first time, and certainly came across better in her direct with a friendly prosecutor. So Alan Jackson did finally get her to admit that she and Carrie Roberts have become best friends, and that they have compared their stories, and that they have talked this, I'm sure they have talked this case to death. Jennifer McCabe admitted early on that she sat down with Carrie Roberts and they together made a timeline both of them sort of contributing what they remembered. So it's clear from the very beginning that their story's been a collaboration. And they are besties. They talk every day. So they were not besties at the time that the incident with John O'Keefe happened, but the whole tragedy and trauma seems to have bonded them, and they are very much best friends now. So, well, that sort of brings us to the point where we can take some questions. And that sort of wraps up what's going on in Karen Reed for this week. Once again, tomorrow's an off day for the court. And Friday, the judge will be hearing, court will be back in session, and Alan Jackson will be continuing his cross-examination of Jennifer McCabe. He told the court he thought he had 2.5 more hours of cross-examination for Jen McCabe. I'm sure she didn't love hearing that. Brennan said he thought he had 20 minutes of redirect. Who knows if they'll be recross and all of that. But I would suspect that the better part of Friday is going to be taken up with Jen McCabe. So, okay, so we're ready for questions. Hi, Edie Ruth. I've been wondering about the trial in the Bahamas that you were following last year. That's Lindsay Shiver. And the Bahamas is not as forthcoming. Hang on, I'm looking for my my list of trials. And it is buried somewhere on my desk. If you could only see my desk. Holy cow. And because as I've been watching Karen Reed, I've been rage crocheting. I don't know whether you can see that or not. So, so I have a big pile of crocheting on my desk too. But the Bahamas is not as, it's not as easy to get. You can't just go on the computer and look up the trial dates. But here's what we know. As far as we know at this point, she is scheduled for trial to start trial on the 29th of July. And so I'm definitely going to be following that. Y'all know I have family in the Bahamas and know a lot of folks down there from all of the years of visiting family down there. And Nassau is, you know, it's a big tourist town, but it's kind of a small town. The people who actually live there and are not, you know, people who just go for holidays. People who actually live there, they all kind of know each other. So I've gotten to know folks in the Bahamas, and I'm going to be anxious to follow that. Now, her bail was revoked, and she spent about 4 months in Fox Hill, which I guarantee you cannot have been fun, even though I've been told that the women's facilities are better than the men's. It's still rat infested, bug infested, not a fun place to be. And if you don't have somebody to bribe the guards and take you stuff, you're going to suffer. But she recently was released once again on bond, and her bond conditions remained the same, which included her being able to go and live with her parents in the United States. I think they're in Alabama, until her trial with a GPS tracker. So she's back out of Fox Hill, the notorious jail, and back in at home with her parents. But she spent about 4 months in Fox Hill for not observing the court's gag order. So I'm pretty sure she is now being quiet as a little church mouse. So we're still seeing lots and lots of pretrial motions on Kohberger. I really expect Kohberger is going to go on schedule, which is the end of June, I think. No, actually, it's the end of July. And jury selection is supposed to start on July 30th. And they say that case could last all the way till November. So I will continue to watch the pretrial motions and see what's going on. But so far, the defense has not been doing well on those pretrial motions. They have been, the judge has been letting in a lot of stuff. So, we'll keep an eye on Lindsay Shiver, and if it happens, we'll cover it. I don't believe there will be any sort of live stream or any sort of access in the courtroom unless you're there. I'm not sure you'll know what's going on, but we shall see. Hi, Ross. Can prior bad acts be brought up when Lori is sentenced? Will this trial impact the one involving Brandon in any way? Good questions. Yes, this trial will impact Brandon because it happened before Brandon's. They can bring that in to show motive and planning and all those sort of things. So they'll argue that really the attempt on Brandon's life was just a continuation of what they were trying to accomplish when they killed Charles. So that can come in Brandon's hearing. Now, the judge has, at Lori's request, set sentencing out until after Brandon's trial. So we're not going to get any sentencing until after. But yes, bad acts come in. So, and prior convictions come in. So when Lori was sentenced in Charles's case, one of the considerations will be her criminal history, and her criminal history isn't that good because she's got 3 life sentences and 3 murder convictions. So yes, that gets taken into consideration because those are prior convictions, and sentencing is different than that information coming in at trial. So the whole issue of prior bad acts only applies to trial. It doesn't apply to sentencing. So it's sentencing, all of that's going to come in, including potentially her allocution from her Idaho trial. I mean, they could introduce that at this trial as well. So all of that information is going to come in at sentencing. And because Brandon's case is ahead and she hasn't been sentenced in Charles's case, at the point where she is eligible for sentencing, they could take both of those cases into consideration. Hopefully that makes sense. So because she's not going to be sentenced on Charles' case until after Brandon's case is over, if she's found guilty in Brandon's case, that could be used against her at her sentencing for Charles. So once you get to sentencing, pretty much all bets are off in terms of what the judge can consider when deciding the sentence. Good questions, though. Hi, Tiff. Did they not have a kennel for Chloe? Not that I know of. My understanding is there may have been a dog run in the backyard, but that would not have kept her quiet while all that commotion was going on in the front yard. So I can see the sun is starting to go down and my lighting is getting a little weird. So, it's just that time of year. But my understanding is that she wasn't kenneled in the house, that she had a run in the backyard, but that she slept in the Albert's bedroom at night. What else you got for me? Hi, Rachel. I want to know how the defense got a hold of the info about the FBI today. That was the most interesting thing I've heard so far this round. So they sent to the FBI a request for information. You've heard, I'm sure you've heard, not only in this case, but in a lot of cases, something called a TUI letter. That is like a lot of things, it's based on a case. So essentially what it is that the FBI doesn't have to give anybody any information. So what you have to do is you have to send a TUI letter to the FBI and request that they release information. And then it's up to the FBI to decide what they're going to give you. So my understanding is that the information they got from the FBI, both the defense and the prosecution, was the result of TUI letters. And it's really at the discretion of the FBI what they release and what they don't. That is not the same when a local agency asks the FBI to come in and assist. Okay. It's like two sides of the coin. So, for example, in the Vallow case, you saw several FBI agents come in and testify about their part in the investigation. We saw tool marks person. We saw somebody who came in and talked about a forensic anthropologist. We saw the FBI's forensics lab had a piece of it. So we saw quite a few people from the FBI. These were people who local law enforcement asked the FBI to come in and assist. But in the Reed case, the FBI got involved because they're literally investigating the investigation. So for the FBI, there is an ongoing potential criminal investigation. And so that means that they have way more discretion about what to release. If law enforcement has invited the FBI in to assist, then the FBI turns everything over to local law enforcement. That doesn't happen when the FBI is involved as they are in Reed. So they send a TUI letter, which basically says, could I please, pretty please have this information? The FBI gave them several thousand pages of information about their investigation, including all of the information from ARCA, from the crash daddies. So that's how everybody got that information and even knew that ARCA was on the case. Nobody knew about ARCA until the FBI, in response to a TUI letter, provided all that information. So whatever they got from the FBI, they got through that process. So good questions. What else? Does that fly in Massachusetts, keeping privacy of his sources? I'm not sure what you're asking. The FBI absolutely, the FBI never has to turn over anything. So they're never going to turn anything over that might compromise an ongoing investigation. Now, Turtle Boy. Now they have been cagey about whether or not that investigation is over, whether they have wrapped up that investigation, and whether or not it's going to result in any charges. The police chief, who's now retired from Canton, announced that the FBI had finished their investigation, but we have never seen anything official from the federal government saying that investigation's over. So we don't know. I mean, I don't think that anybody's hanging their hat on what the now retired chief of police said. Hi, Bo Peep. Do you think there's going to be a problem with law enforcement's not getting a warrant for Stephen Stern's cell phone, even though they have video where he agreed to give it to them and search it? No, I don't think this flies. I think that that every defense attorney would be committing malpractice if they didn't file this motion to suppress and they didn't challenge the law enforcement's right to seize the phone. But I think that I just don't think you can parse it. I mean, basically what he says is, well, I gave them permission to look at the location and the maps, but I didn't give them permission to look at, and I don't think it flies. Just, I think there's sufficient case law out there to support what Florida did and what Florida law enforcement did. And yeah, he's on video giving them permission to look through his phone. So, there's also this element of they get permission to look through his phone. So how much of what they saw was really kind of, I mean, I think they might even argue it was in plain view. We don't know what his screensaver was. We don't know what, I mean, once they opened the phone to look at maps and location data, what else was right there in their face? So, yeah, I don't think it flies. I think the trial got postponed while that it was enough of an issue that the judge postponed the trial while that gets decided, because if they don't have the phone, then their case is less strong. They did find a hard drive or a thumb drive in his father's storage unit in some property that was pretty clearly Stephen Stern's property, that also had images on it, and they did have a warrant to search that storage unit. So they do have those, but obviously the connection to his cell phone is certainly much more compelling. Also, I am unclear whether the images that were recovered off the hard drive included Madeline Soto, but the ones on his telephone clearly did. And that is certainly a precursor or a aggravating factor to the murder charge. So, I mean, best case scenario would be that they get the phone in, and I kind of expect they will. I just don't see that that's going to be clear cut enough. Had he handed them the phone and said, you can look through my location, and then taken the phone back and said, that's all you can see, that would be different. But he didn't. So once they had it, they just kept going through it. So, hi, Donna B. Shouldn't the Daybell juror have reported to the judge if he learned of her prior convictions, like the juror who saw the body cam video did? Yes, I think that the juror probably should have. I guess my question is, did the juror know that information during voir dire? If the juror knew that information during voir dire and wasn't, I mean, this is sort of it's sort of a dicey question, because how much questioning do you do of a jury panel and risk giving information to people who otherwise wouldn't have known it? This is one of the reasons why in Idaho they did their voir dire individually, because they didn't want questions that they were going to ask this juror, the juror sitting next to him, going, now I need to know more about that, and sort of tipping people off. So perhaps during the voir dire, they didn't go deeply enough into that and ask those questions. And if the juror was never asked, then I guess he could say, nobody asked me. Yeah, I'd heard about it, but didn't mean I couldn't be fair. So I don't know. I certainly think that it's going to be an issue that Lori Vallow is going to raise, and Lori Vallow is going to make as much of it as she possibly can, because she doesn't have a lot of appellate issues. But if there are jury irregularities, that certainly could be something that she could raise. Oh, hi, Marie. I'm sort of a novice crocheter. So I spend a lot of time sort of putting a row in and then taking a row out because it's not quite perfect, but it's just a little blanket, and it's just kind of more for practice and to keep my hands busy so I don't lose my mind while I'm watching Karen read. So sometimes I make cotton dishcloths because I like dishcloths. So sometimes I make those when the great thing about cotton dishcloths is you can wash them and wash them, and when they fall apart, you just throw them away. Then you make new ones. So sometimes I do that. But this is just a little blanket, and I don't know whether I'll finish it or whether I'll end up taking it apart before I perfect this stitch. We'll see. So. Hi, Rachel. Do you think the fact there have been several slips about the first Karen Reed trial will affect the jury at all? And does that slip happen in other retrials? Yeah, it does, no matter how hard you try. So there have been, and it has really been on the part of the witnesses. I have to say, I think that the attorneys have been pretty, and the judge have been pretty good about not saying the word trial. They've said in prior proceedings. But Carrie Roberts several times said in the last trial, in the prior trial. So it certainly doesn't rise to the level of a mistrial, and frankly, nobody wants a mistrial. So neither side is raising it as an issue that is going to, they would have to raise it. So defense or prosecution would have to say, there have been so many references to the prior trial that the jury can't be fair. And I don't think they're there yet. And I think that they've been careful, and I think they're going to be more careful going on. So I see Jackie saying it's bedtime on the East Coast and good night. So we're getting ready to wrap up as well. So let's take a couple of more questions, and then we'll be finished for the evening. Let me know if there's questions I haven't answered, and also let me know if there are other cases that you have questions about. So any last questions before we wrap? Do you think, oh, this is Rachel's question. That's not a new one. So I want to say thanks to everybody who is here tonight. I know that you could spend your Wednesday night a lot of ways, and so I appreciate it when you spend it with me. I see lots of familiar names in the chat, and I appreciate you. I appreciate that you're always here on Wednesday nights. Please, if you haven't already, hit the like button. Please subscribe if you're not subscribed. We do occasionally do surprise lives. And thanks again for joining us. Thank you so much, Jen, for always being here and being the best moderator in the world. Jen is getting ready to move house, so she's up to her eyebrows. So I appreciate especially that in the midst of all of that, she's with us. And trust me, 3 moves in 5 years, I know about moving house. I'm not doing it again. Famous last words. Please hold me to it. I'm going to say good night, and we'll see you next week.